Elon Musk's xAI just lost a lawsuit against OpenAI over trade secret theft, and I mean completely lost. The entire case got thrown out by the courts. No settlement, no partial victory, just dismissed. This is a moment that reveals how messy and legally fragile competition has become in the AI industry. Here's what happened. xAI accused OpenAI of stealing its proprietary methods, the secret sauce that makes an AI system tick. They claimed OpenAI used xAI's confidential techniques to build their own models better and faster. If true, it would have been a massive deal. The court could have forced OpenAI to reveal how they actually built their systems, potentially reshaping the entire industry. Instead, the judge said, "There's no case here. Case dismissed." So what was xAI actually suing over? What evidence did they think they had? And more importantly, what does this tell us about the future of AI competition when the companies are this litigious, this territorial, and this willing to fight in court? And here's where it gets interesting. Think of the AI industry like the early days of the car business. You've got the established players, OpenAI with ChatGPT, Google with Gemini, Anthropic with Claude. They are the Ford and General Motors of AI. And then you've got Elon Musk with xAI, essentially saying, "I'm going to build something better than all of you." xAI launched in 2023 with a very specific mission. Musk was frustrated with what he saw as ChatGPT's limitations. It was brilliant at answering questions and generating text, but it wasn't building genuine reasoning. It couldn't truly think through complex problems step by step. So he funded xAI to build reasoning AI that would understand causality, verify its own logic, and actually think like a human expert would. The problem? Building AI requires data, talent, and computing power. All three are expensive. And OpenAI had already raised nearly $20 billion, had Sam Altman as its CEO, and had secured partnerships with Microsoft worth tens of billions more. xAI was the new kid trying to outrun established players with massive head starts. This is where the lawsuit came in. xAI claimed OpenAI had stolen its proprietary techniques, the methods xAI had developed for training better reasoning models. In other words, xAI was saying, "You didn't just outrun us on money and partnerships, you stole our playbook," and that would explain how OpenAI could compete so effectively. But the court disagreed. But here's what most coverage gets wrong. Trade secret lawsuits need three things. First, you have a secret. Second, it gives you competitive advantage. Third, the other person accessed it and used it. If any breaks down, your case fails. In xAI's case, they claimed they developed proprietary training techniques for reasoning AI, methods to teach AI to think better with fewer hallucinations. They said OpenAI had accessed these techniques and used them to improve their own models. But here's what killed their lawsuit. The judge ruled xAI hadn't proven access. In AI development, tons of companies independently work on reasoning improvements. Everyone's researching similar problems. Everyone's publishing papers. Everyone's hiring talent from competitors. Without clear evidence that OpenAI specifically took xAI's methods, not just came up with something similar independently, xAI had no case. It's like accusing someone of copying your essay when you both wrote about the same topic. Without proof they actually copied from you, you've got nothing. The courts were saying, xAI, show us the smoking gun. You haven't. Case dismissed. This matters because it reveals something fundamental about tech IP disputes. In industries like software and AI, where techniques converge naturally, where papers are published, where talent moves between companies, proving someone stole from you is almost impossible. You need emails, documents, or a former employee testifying. Coincidental similarity doesn't cut it. This is the twist nobody expected. History's full of companies accusing each other of theft, and the results are almost always anticlimactic. Apple sued Samsung for copying iPhone design and won, but the damages were way smaller than the hype suggested. Google sued over smartphone patents repeatedly, and most cases settled quietly for pocket change relative to the company's valuations. Why? Because in tech, convergent evolution is real. When you're solving the same problem with the same constraints and the same starting point, you often end up at the same answer. Two different teams can independently invent nearly identical features and both be totally honest about it. They didn't copy each other, They just both figured out that this is the obvious solution. The AI industry is even messier. Everyone has access to the same published research papers. Everyone can see what competitors announce publicly. Everyone hires from the same talent pool. So when xAI claims OpenAI stole their reasoning techniques, the skepticism from the courts makes sense. They are saying, how are we supposed to prove causation here? Consider that OpenAI already had ChatGPT working brilliantly before xAI even existed. OpenAI was already working on reasoning capabilities publicly, sharing research papers, collaborating with Microsoft. xAI would need to show they invented something specific first, then prove OpenAI specifically knew about it and copied it. That's a much higher bar than we both have reasoning AI now, and xAI apparently couldn't clear it. But here's what this means for the future. Let's zoom out. xAI and OpenAI are on totally different trajectories, especially now. OpenAI's been around since 2015. They've raised $100 billion in funding and partnerships. They've got Microsoft backing them. They've got ChatGPT deployed to hundreds of millions of people. They're already winning the market war. At this scale, a lawsuit from a younger competitor isn't existential. They can afford legal teams. They can afford to fight. And they won. xAI, by contrast, was founded in 2023. They are 3 years old. They've raised billions, sure, but that's pocket change compared to OpenAI's war chest. They're still proving they can ship a product people actually want. Grok, that's xAI's AI assistant, exists and people use it, but it's not the household name that ChatGPT is. xAI's still in the fight for survival in a crowded market. And now they've lost a legal bet that would have been a Hail Mary if it had worked. This lawsuit was xAI's attempt to level the playing field. If they'd won, they could have forced OpenAI to reveal methodologies, settle for damages, maybe even license xAI's techniques. Instead, they burned time and money on a case the courts threw out immediately. That's not just a legal loss. That's a market signal. It says xAI's accusations weren't serious enough to stick. And here's what that does to their credibility. This dismissal has real consequences for how AI companies will compete in the future. First, it signals that trade secret lawsuits in AI are nearly impossible to win unless you have slam-dunk evidence of espionage, stolen documents, recorded conversations, former employees testifying they brought your code over. Courts aren't buying they have similar capabilities as proof of theft anymore. The legal bar just got higher for everyone. Second, it means xAI's credibility took a hit. When you publicly accuse a giant competitor of stealing from you and lose in court, the market interprets that as their claim wasn't credible. Investors notice. Partners notice. It's not fatal, but it's a scar. xAI's got to rebuild trust by shipping better products and winning in the market, not in the courtroom. Third, and this is huge for the entire AI industry, it tells companies they can't use litigation as a competitive weapon. Litigation is expensive, it's slow, it's public, it damages your brand, and as xAI just learned, it doesn't work if you don't have concrete evidence. So other companies watch this play out and think twice before filing their own tech theft lawsuits. That leaves competition to happen where it actually matters, on product quality, on speed, on funding, on talent recruitment. That's actually healthier for the entire industry. But it's a loss for smaller players who might have hoped courts could level the playing field. Here's what the headlines aren't telling you. So how do companies actually protect their intellectual property in AI? There are 3 main strategies. 1. Patents. You file a patent describing your invention. It's public, but you get a legal monopoly on it for 20 years. The problem? AI techniques move faster than patent courts do. By the time a patent case concludes, the technology's often obsolete. Patents work great for hardware. For software and AI, they are slow weapons. 2. Copyrights and code protection. You don't publish your code, you keep it proprietary. This works if you can actually keep it secret, but it's a liability if an employee leaves. A single person downloading your entire codebase and taking it to a competitor can destroy this strategy overnight. That's why high-level tech jobs have non-competes and confidentiality agreements. They're trying to lock people down. 3. Trade secrets. You keep something truly secret. It's not published, you have clear controls on who knows it, and you defend it aggressively in court if someone steals it. This is the strongest protection legally, but only if you can actually prove theft happened. That's where xAI stumbled. You need emails showing someone requested your secret. You need documents proving they received it. You need a whistleblower. Without that, courts say I can't help you, and that's the part that changes everything. Here's what this lawsuit tells us about the state of the AI industry in 2026. Legal warfare between AI companies isn't going to be the deciding factor in who wins. Courts are saying, if you're going to accuse someone of stealing, bring proof, real proof, not just circumstantial evidence, not we both have reasoning AI, bring documents, bring witnesses, bring something a judge can sink their teeth into. That's a massive advantage to the larger, more established players, OpenAI, Google, Anthropic, because they can outspend smaller competitors on R&D, not on litigation. It also means the future of AI competition is going to be won by execution. Who can ship better products faster? Who can recruit better talent? Who can raise more capital? Who can iterate quicker? That's the real war. xAI has to compete on product quality. They've got grok. They've got ambitions. But now they're facing an uphill battle on the product side, not a shortcut through the courts. For you watching this, the takeaway is simple. When you see companies suing each other for IP theft, treat it with skepticism. The fact that they are in court usually means the case is weak, because strong cases often settle privately before trial. Remember that for everything you read about tech drama in the news, follow for daily AI news, and we'll break down the next courtroom surprise as it happens.